Hema Malini, a popular Bollywood actress who has endorsed a brand called Kent Arrow. Do you know the revenue of Kent? It is nearly 7,654 crores. And in order to make this brand really popular, they are spending nearly 1,106 crores in marketing. Recently, the Kent Arrow System company wanted to actually enter into the market of fans. But here comes the problem. The company, which was already very popular, was not allowed to sell under this category of fan. Do you know why? In this video, I'm going to tell you about another brand which was already using the name Kent for fans. And how did they manage to stop Kent Arrow from using it for fans? Did they have already the registration? We are going to explore it completely, and most importantly, all the business owners out there, you are thinking that if you have a registered brand name and if your name is really popular, you can use the brand name for any category. That's not the case. In this video, we'll explore. Myself Rohini, your corporate lawyer from Lee Intelligentsia Private Limited. Now we need to go to the background of the story of the brand Kent, which starts from 1980s. Kent, a popular brand, was already used by a company called Kent Cables, and they registered this name Kent under Class 9 in 1986. They were using this brand name for various electronic goods like wires, cables and switches. Now here comes the popular brand name Kent Arrow. They actually filed a trademark in 1986, but they filed under the category of Class 9, which is specifically related to water purifiers. Now in the year 1998, Kent Cables wanted to enter the market of fans. So what they did is, they filed a trademark under the specific class of fan category, and they mentioned the application as proposed to be used. Proposed to be used means they have not yet started using it, they are going to use it. This is what the status when they were filing the trademark application. Now let's come to Kent Arrow water purifiers. Though the Kent Arrow water purifiers filed the trademark in 1988, they started using the RO purifiers from 1999. Since the company was growing very well, they were not only in the market of water purifiers, they expanded to air purifiers, vacuum cleaners and many other kitchen appliances. Kent Arrow wanted to enter the category of fan in the year 2011, but here is the important catch. Kent Cable actually filed the trademark in 1998. But they started using the Kent name for the fans from 2009. Now they are sending a legal notice to Kent Cables to stop using the name Kent under the category of fan, but did not take any legal actions in that scenario. And there comes the war between the two important competitors. In the year 2022, what happened was, Kent Arrow System actually filed a case before the Delhi High Court against Kent Cables for stop using the name Kent for fans. Now what happened is, when Kent Arrow filed this case, they made a detailed argument stating that they are a company which is very popular all over in India and they have a revenue of nearly 7,500 crores, and to make this name Kent really popular in India, they have spent more than 1,000 crores. And claiming all of this, they stated that when they wanted to enter into any new category of product, they should be given the preference because they are really famous. But court did not accept this argument. Court actually took into the point of who is the prior owner of this name Kent. Who has the registered status? These are the two important questions raised by Delhi High Court. To answer this question, Kent Cables actually filed a trademark in 1998 to use the name Kent for fans. But they were not actually using it. They started using it for fans only from 2009. So what they did is, they submitted a detailed evidences for date of usage. That is from 2009, every year they submitted invoices. Every year they submitted the advertisements related to that. They also submitted dealer records and agreements that they had. Since this evidences was nearly a solid evidence for prior use, and also they have registered the brand under this class of Class 11 from 1998 itself. So this brand is having a solid stand in trademark registration and solid stand in prior user than Kent Arrow Cables, who have only launched the brand newly under fans and they do not have a registered status. But Kent Arrow System actually applied under Class 11, for RO water purifiers, where fan also falls under that category, but they did not choose to register for fan under that category. In 2023, Delhi High Court gave an order which was against Kent RO to stop using the brand name for fans. The two important reasons for this interim order was Kent Cable had a prior usage with solid evidences, as well as they had a registered trademark for the category of fans. But Kent RO company is really huge. They wanted to file an appeal before the division bench of Delhi High Court, but Delhi High Court division bench also did not accept their argument, and they said they cannot use this name Kent for fan category itself. But they did not stop here. Kent RO system went to Supreme Court of India in the year March 2026. Recently, in the month of August 7th, 2026, that is this month, what happened was Supreme Court stated that Delhi High Court's observation was correct and the interim order stays. They could not use the brand name for fans. Only reason was they did not have a registered mark, they did not have a prior user. Now here comes the 5 important business lessons. As a business owner, if you are going to use your brand name for one particular category, you will file a trademark for that category. But in future, if you have any other products to be launched and you have a plan for that to expand, then it is very important that you apply for a trademark registration, and while applying, do not forget to do a thorough trademark search. The number 2 is the product and the exact goods and services. Whenever you're applying for a trademark, you might be applying under one class, and under that class there are hundreds of products. If you are filing any application under one category of trademark, you can choose to mention many products which is covered under that particular classes. The number 3 important lesson is preserve the evidences for date of usage. Whenever you're starting to use any brand name for a particular business, you need to keep the evidences at least in a year, 2 to 3 invoices, any marketing documents that you have, any vendor agreements that you have. All these details can be collected, which will serve as a proof for you when the case comes before the court. The number 4 business lesson is whenever you're launching your product, you will launch it in one particular category, but you will have a vision to go in multiple products. When you have such vision of expansion, try to protect the brand name as early as possible in different categories of trademark classes. The number 5 business lesson is the misconception. Many entrepreneurs think that if we are a popular brand or if we are a bigger brand having a lot of money, we can win over the trademark case. That's not the real scenario. If any other competitor has a prior use or if he is having a registered mark, then your popularity may not serve before the court. If you are a business owner, I have an important question for you. The question is, who has a stronger right on trademark? Whether it is a prior user or a registered user. Whoever it is you feel, comment below in the comment box with the supportive reason. Like this, more useful video will be posted in our channel. Do not forget to subscribe to our channel. Myself Rohini, your corporate lawyer from Lee Intelligentsia Private Limited.